Hello, my name is Mary Mack, and I'm the Executive Director of ACEDS, the Association of Certified eDiscovery Specialists. And we're here today with a wonderful webinar entitled Efficiently Handling Regulatory Requests. This webinar is sponsored by Zilab. We're very grateful for their sponsorship and your attendance. Our speakers today are experts in the field of regulatory requests and eDiscovery. We have Maytel Gongaleski. She's counsel at Baker and Hostetler, and she is part of the eDiscovery advocacy and management team. May has been counseling clients on issues relating to electronic discovery, data privacy, software licensing, and general law and technology issues. She's not only an attorney, she's also a programmer, so she understands the technology behind licensing, data mapping, and eDiscovery. Having practiced abroad, she's particularly sensitive to international issues. With her, we have Johannes Jan, we like to call him Jan Schultes. He's the Chief Strategy Officer and co-founder of Zilab. He's a professor of text mining at the University of Maastricht. And he's also been involved in many of the regulatory events, not only here in the United States, but also abroad, and has a deep well of technical knowledge on how to approach these. And we're going to cover quite a wide agenda on the regulatory issues. And what we'll be talking about will be how eDiscovery practitioners can efficiently get through a regulatory event. So, May, can you give us a bit of an understanding of your experience in particularly the regulatory area?
Sure. Hello, everyone. Thanks for joining us today. I've been practicing discovery for quite some time, and I realized that there is a very stark difference between civil litigation and regulatory investigations in the sense that they are more stressful to our clients. They usually involve larger magnitudes of data, a large number of custodians, and then a very, very demanding, proficient, and savvy entity on the other side. As opposed to civil litigation, where we have more leeway and more flexibility to negotiate number of custodians, volumes of data, types of data, sources of data. I realized that we have less flexibility, much less flexibility when it comes to regulatory investigations. And the process is usually moving faster with very tight deadlines, less flexibility to negotiate those deadlines, and that production has to be almost perfect. Including a lot of information, many metadata fields. Aside from that, there are so many moving parts and so many people who are involved. Client contacts, IT, legal, a lot of people on the firm side, and of course, there's always a vendor. So there's a challenge to put processes in place, effective communication, and make sure that every group is communicating effectively to the other in order to facilitate that process.
So, May, for our listeners that are part of multinational organizations or that serve multinational organizations, what do you see as the biggest challenge when an organization like that gets a regulatory request?
There are a few challenges. The first one would be the realization that they have to produce very large amounts of data, and that sources that they wouldn't consider as responsive in Europe are actually responsive in the U.S. Also, there's often friction between local laws, labor laws, data privacy laws, bank secrecy laws. There's a friction between these bodies of law and the U.S. laws. There is there's a different type of expectation of privacy in the workplace in Europe, and data that is easily harvested and much more accessible here is much more difficult to obtain from your European client. And usually when a European client, specifically European, other international clients as well, but specifically European clients, when they were hit with these regulatory requests, it took quite some time to effectively communicate with them. I realized that many U.S. attorneys, even attorneys that I was working with extensively, didn't realize that there were issues with those contradicting laws, and they would start handling the request as if they were handling one here, but then about 2 weeks after the fact, they would call me, and then they would realize that they missed something, that they couldn't actually preserve that type of system, or they couldn't really ask somebody in Europe to gather all their email and transfer them here, or even have somebody here review such emails remotely. So I think that when it comes to European clients, there are two layers to that. The first one is to, even the psychological factor, to explain what's going on, what needs to be done, and then to understand the challenges that the European client is facing because they're subject to specific laws and regulations.
And are you finding that the regulators are sympathetic to the privacy argument? Are the regulators educated on this issue?
It depends. I can tell you that asking a regulator to withhold discovery or production for a certain custodian or for a certain system because they're subject to data privacy laws, that doesn't fly. But explaining the problem and trying to mitigate the issue and find some golden path, I realize, from my experience, regulators are definitely open to that. If they're a part of the process, if they're aware of the issue up front, not later down the road, 2 months after, a week before production deadline, then they're definitely open to stamping a document that's confidential, subject to European data privacy laws, and let's produce for these custodians as opposed to that custodian. Let's redact. Let's produce information that is not inherently considered as personal data before we get to the personal data. There are many things that you can do. I think that communication is probably the most important thing. Don't hide the fact that you're relying that the data is subject to data privacy laws. Discuss that up front, flag that up front, even on the first call with the regulator.
So you're as I'm listening to you, I can hear you, like there's a lot of zigging and zagging going on. How, are all vendors equally experienced in this type of regulatory production and the activities that go on, or are there some things that organizations facing these regulatory requests should be specifically asking for from their service providers?
Well, I think that all vendors are definitely not created equally, and I think that it's crucial to work with a vendor who is both sensitive to data privacy laws and can advise and be creative when it comes to designing the project in order to mitigate the friction between data privacy laws and the U.S. regime. And there are many things that can be done, and I'm sure Jan can talk a little bit about that either now or later. Some clients prefer that we export or transfer a minimal set of data out of the EU. So many clients prefer to review in Europe. They don't let us take everything out and review here. So a vendor that could help with that would definitely have an advantage. Some clients say, you know what, I don't even want you to take the data out of my headquarters. So we need a vendor to actually come in with a mobile server and processing machines and do everything on site, and then allow me to log in with very limited viewing rights. So I need a vendor that understands that this needs to be done and can actually accommodate for that. When it comes to the production, some clients say, okay, we reviewed here in Europe and we distilled the responsive set to, I don't know, these documents, but we still don't think that there's still information there that needs to be redacted, but we can't go and physically redact every document. So a vendor that offers tools that can automatically redact or anonymize names and ID numbers, social security numbers, or the European equivalent, it could save time and money and again, help clients comply with all those laws and regulations. Of course, vendors that also understand, they don't only have to understand the European restrictions, they also have to understand what we're facing here. So to help on both fronts. So it definitely makes a huge, huge, huge difference if a vendor can speak data privacy, can speak U.S. discovery to help tie all the ends together.
Well, that is really interesting. So I had some questions from some of the certified e-discovery specialists around agencies, and what's your experience with the agency's current ability to scale and their use of particular tools to investigate?
I know for a fact that some agencies license analytics and they license predictive coding tools, and it could vary. And I feel that as opposed to negotiations in the past that we conducted where we would negotiate search terms extensively, now even if I want to do that and I feel that my universe is not large enough for the application of analytics, at least on my end, I feel that regulators come and say, you know what, let's just produce, I'm not going to say everything, but produce a larger universe because we have tools on our end. But the problem is that I would still need to know what I'm producing. So that makes me apply analytics even if I was not going to. And at the end of the day, clients are concerned with price. They're concerned with the process. And you know, with predictive coding, you would only know at the end once the project is concluded whether you saved and how effective it was. You can't know that up front. So there's a lot of friction between. I'm working on a case right now where client is very cost sensitive and they want to go through the classic exercise of search term negotiations, and the regulator on the other side comes and say, why don't we do a mutual predictive coding exercise? Let's just do a mutual iteration exercise where you produce something to me, I run it through my analytics, I'll let you know if I need more. You produce another set, I'll let you know if I need more. If I don't, I just tell you to stop, and that's your production set. And I can tell you that I've not done it this way before. I might have used predictive coding on my end and shared the protocol with the regulator, but this is new. I definitely feel that they're looking for larger, more inclusive universes. I mean, it's easy to receive; it's harder to give.
It's interesting. It sounds almost like they'd like a quick peek opportunity, and you know, many of us have been concerned about putting material over that has not yet been reviewed or marked appropriately.
And not just that, the types of data that they're looking for, the sources, it's no longer email. In fact, the case I'm working on right now is mostly not going to revolve around email. It's going to revolve around structured data from certain systems, from Oracle and SQL databases, from Salesforce databases, from dedicated servers and homegrown applications. It really depends on the case, but I think that a lot of information these days is not really around emails. We create data on so many sources and so many devices, and email is almost obsolete in some cases when some practices are investigated, where the data regarding such practices resides in a database. And so with predictive coding or with AI, you can sift through this data, understand, and create a picture, a bird's eye view of these types of data. And I see where they're coming from. They definitely want to have more to see what they're looking for is right there. And with search terms, they don't know my client. They don't know, maybe my client has a code word for something, and if it's not in the set of terms, the documents will never be captured. So I see where they're coming from, but I also see where my clients are coming from. So there has to be some understanding that, we're trying to comply, we're trying to produce, but, we're not in the business of the clients are not in the business of responding to regulatory investigation. They're in the business of conducting their business. So there has to be some understanding that it could not be, that the process has to be efficient, cost-effective to the client in order for them to comply.
And this is sounding like an advance on the part of the government regulators as opposed to, say, a commercial opponent in a civil litigation. Do you see distinct differences there?
Yeah, it really depends, again, on also the jurisdictions and the type of firm on the other side. There's definitely, there could be another very sophisticated law firm on the other side, and then I would feel they're as sophisticated as a regulator. But sometimes I work with certain jurisdictions where it's old school search terms and email only, and I had a law firm that asked me to produce something via a Dropbox link, which would never fly and not be acceptable to a regulator, and to some, in some jurisdictions that would not be acceptable as well. But it's a different world. I could control or negotiate fiercely and refuse to produce certain fields that have nothing to do with the subject matter. I could focus on certain custodians, and again, it depends whether I'm the plaintiff or whether I'm the defendant and the leverage that I have. But much smaller, the scopes are much smaller, and it's a whole different world. Of course, if it's civil litigation here in the U.S., usually we don't have the data privacy issues, unless, of course, it's a foreign party. But definitely, I feel that I can be more aggressive when it comes to civil litigation.
Yes, a little bit nicer in the regulatory area. Regulatory requests sometimes come with very, very short deadlines, or sometimes a firm is brought in at the last minute to comply with a regulatory request. Maybe some things have been done before. Do you have any tips for sort of walking into that storm?
Yes. I think the two things that need to be done up front. The first thing is to get a good understanding of what was done before, whether it was another firm, whether a client was involved in some of the preliminary activities, and then pick up the phone, arrange for a call with the regulator, introduce yourself. You're here to help, you're here to comply, and try to, whether a deadline needs to be moved, then this is something that I would do up front. And whether sometimes I, as an attorney stepping in, I sometimes have questions about the request, the types of data. Maybe I'll try to negotiate some scope. But I think communication is probably the most important thing as you step into a new investigation. The next thing that I like to do personally is to have a call with the client's IT and to map the system. I need to understand, and that's before the custodian interviews, because I like to come prepared to custodian interviews. I like to know what they're using so they don't surprise me. And sometimes they do, but I prefer to know what the firm looks like, what the firm's IT looks like before I speak to custodians. So when I come and talk to the custodians, and they neglect to mention something, I'll say, oh, so aside from email, I know you have an archiving system, or I know you're using AutoCAD because you're into architecture and you have all these blueprints about that resort that was built. and it helps me to direct custodians to the right sources. And after those two exercises, I'm in a better position to go back to the regulator to discuss systems, sources. I personally prefer not to produce complete databases, so I can discuss sampling from certain databases. I could let some sources drop out of the litigation hold or the preservation hold because now I know that they're not relevant. So I think the most effective thing to do right after you communicate with the regulator is really get to know the client. Don't ask. It's not even about subject matter. It's not about anything substantive. It's all about discovery. I feel in the first instance, and after that, you can find out which systems hold the data that you need, which people hold the data that you need. You just focus on these people, and you let your client resume to normal practices where it can do so.
Well, it certainly is challenging, and technology can help. And Jan, do you want to talk a little bit about how technology is like the perfect use case here for regulatory?
Yes, no, absolutely. Welcome, everybody. Also, thank you for having me here. My voice is a little broken, which has to do with short-term fever, so I apologize for that. But yeah, let's see how this works. So when we're talking about regulatory requests and how technology can help with that, it's the majority of these cases are competition and antitrust violations. But we see a lot of new regulators also internationally that are conducting similarly disruptive requests, which are related to several other areas like environmental issues, healthcare, consumer protection, food and drug safety, and of course there's all traditional ones like financial requests for investment advisory or bribery and other types of fraud. What can they do? And you have to help me here, May, as I'm not a lawyer. But what we see is that these regulatory agencies, of course, they can set regulations, they can perform inquiries and investigations, but they also may fine people, or in the US, they can even jail you. But in some cases, they're also allowed to perform internal investigations. They can even instruct shareholders to replace the current management. And of course, they can seize data, and especially when they seize data, the investigation or the inquiry can be very disruptive. And you could be like 3-0 behind directly after the seizing of data. And it's very important, and time is of the essence, to understand as soon as possible what really happened. Now, I got a little statistic here from the European Commission, which is just the fines which were issued in Europe on cartels and antitrust and competition investigations, as we call them here. And you can see that the number is actually increasing. And this is just the European Commission on antitrust investigations. There's a lot of other fines they did. And then in general, the fines of the US regulators are, of course, much higher. And if you look at the financial industry, what they have paid over the years to U.S. regulators, the amounts are enormous. And this is something I found on LinkedIn. And I think it shows all the banks with the enormous amounts of fines that they received for violating a whole set of different regulatory requirements. Now, what we see is that what our clients are most concerned about, and these are not only the companies but also the law firms representing them, is that when they do answer a regulatory request, the answers have to be complete. Like May said, they have to be the answers have to be acute, so you have to right away answer them. There's no time for delay, and they have to be timely. Now, what we see is that if you accidentally withhold or you don't provide information, that can lead to dawn raids, on-premise investigations, And if information is obtained by regulators from your competitors or whistleblowers, they can lead to very unexpected pawn rates and information seizure. So this is something which one has to take into account. But like I said, time is of the essence. After an information seizure, there's an information asymmetry. You don't know what happened. You need to indicate with European agencies very quickly, sometimes within 10 days after they seize the data, what is responsive, what is not responsive, and what is privileged. So they give you a copy of the data they seized, or they give your lawyer a copy of the data, and you have to go through this. And you also have to know very quickly what really happened, because the sooner you know what really happened, the sooner you know who were involved, what did they do, who were their affiliates, how did they do it. You can start planning your own strategy, and that's only when you can only start thinking about answering these questions. So you have to start your own investigation with your own outside counsel, which we see happening all the time. And then you also have to prepare for additional investigations from other countries, other regulatory agencies, or claims from customers or consumers who feel disadvantaged, that they paid too high prices, or they have been disadvantaged for other reasons. Now, one of the things that we see which is happening more and more in Europe is that companies are actually thinking about how they can prevent an investigation. Because proactively preventing non-compliance, searching for risk, deviations, anomalies, is smart. And doing compliance runs, doing regular independent audits by a lawyer, interviewing people, doing data investigations, is a very wise decision. If you do it by your lawyer or with your lawyer, all the outcomes also fall under the legal privilege. And this is exactly the moment when you want to start using technology, because with technology you can do these compliance runs and proactive runs more efficient. You get better results, you find more relevant data, you have faster insights, and they're more cost efficient. But if you
we have a question. Yeah, we have a question. You're probably going to cover this, so if you are, please, we'll take it in the normal course. But the question is, do the panelists use more than predictive coding in the AI, in the artificial intelligence realm of technology? Are there other facets of artificial intelligence that come into play?
Yeah, no, a whole bunch of those, and I will discuss them one by one. We're using machine translation, we're using audio search, we also use analytics, where we do community detection, we detect sentiments, emotions, and a lot of other tools than just the predictive coding and the machine learning. Yeah, that's a very good question.
Yeah, thank you.
Okay, so why do you need to automate? This is interesting. It's I'm seeing animation 1 of 8. There we go. So why do you need to automate? There's either too many data, too many hits. You never know what you get. More important, you don't know what you miss, which is very sensitive when you're answering a regulatory request. Too many languages, too many spelling variations, too many non-textual formats, audio, video. Data is being spread to many geographical locations, and it's also present in many different repositories. So all of these are the reasons why you no longer can rely on just a traditional search. And it has been proven over and over that traditional keyword search only gives you a fraction of all the relevant documents, contrary to machine learning and AI techniques, which will give you a much higher percentage, often higher than human performance, and that's what we'll discuss now. How can we help with AI and data science? Well, of course, intelligent search, intelligent analysis of the document content, identification, extraction of relevant information, kind of building up a semantic representation of the document, classify information, learning and store knowledge of documents, clauses, and typical things that you can find in machine learning, translation, and also the automatic identification and redaction of sensitive and personal data. Now, how do we do that? With our technology, we can get data from cloud-based resources or from on-premises resources, and then we cover the whole EDRM spectrum, so we can identify the data, preserve it, collect it, process it, analyze it, review it, and then produce it. And we can do this both on installations that can be placed on premises, like May just said. So our clients can take a server, buy our software, and then go on premise and keep all the data within the corporate firewalls or corporate premises. We can also run it in a private cloud, or we can run it in Microsoft Azure, where I'll tell you a little bit more about, or in AWS, and then we can do the different productions. Now, how we can work with Zylab One eDiscovery is that we can analyze the data that was sent or that was seized by the regulator, so you know exactly what they know. This is very beneficial. We can help you to communicate to the regulator what is privileged and confidential information within the legal timeframes. We can help you to start an internal investigation where you do interviews, you collect additional data, and you try to find out what really happened. And then you can do this in your own computer system with your own eDiscovery system, so you can do it independently from any other third party. And then you can use all this information to answer completely, accurately, truthfully, and timely to the regulators. Now, how does it look like? Now, we can collect information from its original location, from, of course, all the Microsoft 365, Exchange, file shares, SharePoint, but also tools like Alfresco and different other file systems. You can also upload the information yourself by uploading PSTs or disks and USBs, zip files, and we have a very user-friendly environment that allows you to upload this data. And we have several clients that upload hundreds of gigabytes overnight, and then the next morning they can start reviewing the data. So we try to keep the time between the identification of the data and the actual start of the review very, very short. So you can immediately start working on closing the information gap between you and the regulator. Now, because in our environment you can indicate what's privileged. Now, the way how this works in Europe is that if you get the data and you want to tell them what's that's seized and you want to tell them what is privileged, you can actually use the Zylab software, because a lot of the regulators in Europe use Zylab, so they accept productions also in the Zylab format. In the US, we also have several regulators using our software, and we also have worldwide regulators. Now, of course, you can also produce in all of the standard production formats that are accepted under normal eDiscovery best practices, but it can be a huge benefit if the regulator that you're working with is using Zylab and you can export the data in the Zylab format. We have very advanced search. We can build huge queries with wildcards and combine it with structured information. A lot of the requests from the regulators are very long. They give you long lists of queries. These queries are often embedded proximity searches or embedded Boolean searches with trailing wildcards and also wildcards in the middle of the word and at the end of the word. Now, we support all of those different variations, and one of the reasons why you might get these queries is that, like I said, many of the regulators use Zylab, so they're used to using this type of search instead of the very limited search that's often available in eDiscovery software or in open source search tools such as Lucene or Elastic. Now, what do you want to search for if you start searching yourself? And this is kind of interesting. And you know, our history is in the search space, so this has always been the eDiscovery use case that's closest to our heart, where we help people to find privileged information. We help them to immediately find and categorize data around individuals, suspects, partners in crime, related companies. You may want to interview somebody, and then you may want to look for companies of competitors, names of competitors in an antitrust case. What are very interesting emails are always the one-on-one emails, where you want to, so where people communicate with each other, so not one email to a group, but one-on-one, or where they identify, where they communicate at all times in the middle of the night, or one of the really interesting parts that we see that our clients are interested in is emails with lots of emotions and anger and cursing and threats, because that's often where the really interesting things are going on, and that's where people may forget about their cover or the fact that they're communicating by email and they get a little bit less reserved. One of the things that the regulators are always looking for, has there been guidance or pressure from the management to commit the irregularities? And then, of course, are there code words or hidden communication methods? And this can be anything from people using Snapchat or WhatsApp, and then sometimes people make a screenshot of a certain piece of communication, which we can recover, and then we can make it searchable and find it. But it could also be that people are not talking about the actual things they're doing, but they're talking in code words. By using advanced analytics, we can actually find these type of code words by looking at all kinds of anomalies compared to normal word and language uses. And we've seen many cases where people, for instance, said, "How many coffee did you give him?" and they're actually talking about money. And then we found that there was this odd frequency of people giving huge amounts of coffee to other people. And then by looking at the email, we found out that this was actually a code word for money. One of the other things is very interesting is that some of these suspects get smarter and smarter. So they're no longer communicating over email. They're no longer using Snapchat or WhatsApp or anything. But then sometimes what they do is they do meet somewhere at secret places. And then although there's no communication of what they discuss and that they're actually meeting there, but then they expense their trip to that secret location. So we've seen cases where we've been able to map the analysis of expenses and phone records, and then we found out where their secret meetings took place and when, and then we were actually able to get more information out of the verdict. So it's really about searching, and it's searching about not always where you know what you want. Now, like I said, we can do these huge queries to find privileged information by searching for domains of emails. We ship our software with a list in that. We can analyze competitors, so somebody can say, "Well, I never talked to these competitors," but if one of your suspects has a lot of email about certain competitors in his email, a lot of names of competitors, you may want to ask him a couple of more questions. Or these are like typical patterns that we're looking for related to price fixing, and how often are there certain types of pattern, or how often do people to talk about destroying email or about price fixing or whatever. Or like I said here, one-on-one communication, especially if it's one-on-one communication to private email, or if they use words like, let's talk about this offline, or they start. We can make these semantic analysis of content, where we can look at what are the organizations that are named, what are they talking about, what do they mean, what is the topic, are there certain patterns that we're looking for, and then by looking at specific patterns. We had another case the other day where we were analyzing patterns of meetings, and then we found that there were a lot of meetings with so-called players, and the word player was actually somebody who was bribable, and we found this because of this odd frequency of this word after this semantic analysis. As I said, we can do sentiment and emotion detection, which gives you a very good indication of the different really hot emails. And then this is just a basic analysis. One of the things we do is we can extract monetary amounts that are mentioned in communication, and then we can make frequency analysis of those. And we've seen cases where there was like a an issue where the amount that was frauded with was 3 million euros. And we found out that after doing these analysis, there were many mentions of 3 million, but there were also a significant amount of mentions of 3 million and 1 euro. And these frauders, they actually, whenever they were talking about their little setup, they were talking about 3 million and 1 euro because they knew that was not the amount the regulators were going to search for. And by finding this odd frequency, we were actually able to find exactly the emails that were interesting. We can do analysis of countries that are visited. We can also do a topic modeling. This goes beyond predictive coding as well. This is actually what we do is we create a cluster analysis of the data, completely unsupervised, and then we find a number of topics. And with each of these topics, we can actually we organize them hierarchically, and this gives you an idea of the content of the data set. Now this is very important, and this is less artificial intelligence or data science driven, although under the hood this is also using AI and intelligent search. But this becomes more and more important, especially when you have a disclosure from the European Union to any regulator outside of the European Union. Under the new GDPR, Global Data Protection Regulations, coming up May 18 next year, it is important that one redacts information which should be protected by the GDPR. Now, what we can do is we can identify this information by using patterns, regular expressions, but also by using word lists. And then we can not only redact them by using the redaction reason, but we can also pseudonymize them by replacing them with the name of an individual. And in this case, it will allow you to disclose information from Europe to the US, for instance, by replacing names with like Mr. A, Mr. B, or Mr. 1, 2, 3, and whenever the regulator is interested in the actual name of the person, they can then show that they do have some real suspicion against this person, and then you can disclose the name instead of disclosing all the names beforehand. Now, this is a process where we have done some projects recently where we had a return of investment of like 20 times compared to human redaction, and we also had a very high 99% accuracy, which is also much higher than human accuracy. Now, typically how we do this is that we take it to a first run, then the lawyers review the outcome. If they found errors or omissions, we update the whole system and we do it again. And then after a number of cycles, typically 7 or 10, we have then reviewed and redacted the data with a very high accuracy. Okay. Like I said, we have integrated machine translation for a large number of different languages. These are not legally submissible translations, but at least they give you an idea of what is in the data. And we see that a lot of fraudsters communicate in different languages that are not common. And then, if you cannot search or understand those languages, you also miss that communication. We can do audio search. We've seen many cases where suspects actually exchange MP3 files or voice messages by email, or they put them into a zip file and then send them over. So they knew this could not be captured by full text search. Now we will identify these files and make them searchable, just as easy as text files. We can use machine learning, both in redaction but also in the classification of documents. And here too, we see a typical return of investment of 15 to 20 times more efficient compared to human beings. But more important is that this machine learning will give you unprecedented high recall levels. With normal recall, if you are a really, really good searcher and you're really skilled and you know all of the details of all of the search patterns and all of the search techniques, you may get up to 70-80% recall if you do a lot of searching. We see that with machine learning, even people that are totally not capable of defining full text queries are able to reach levels of 90% precision by providing examples and reviewing those examples. And even if you make some errors in these review processes, the machine learning technology is very robust to find these type of patterns. What we see is that when you're a corporation and you ask your lawyer or your internal investigation, you use these technologies yourself, why do you want to use them? Now, first of all, it helps you to support the core values and compliance programs of enterprises if you do regular audits and if you do regular checks on compliance. If you have your lawyer using this technology, you can also look at what your lawyer is doing. So there's maximum transparency between the corporate legal department and the law firm, and you can help them. You can see the speed, the quality, and efficiency, and you know exactly what's going on, and you understand when your law firm needs to do deeper investigations in certain parts. You can understand where the risk is, so you can plan prevention programs for the future. You have real-time insight in the investigation of your legal counsel or your investigation manager, and you can also help protect your legal privilege. For a law firm, benefits are that they can offer maximum transparency to their clients. They can provide their clients really with optimal support during the whole investigation. As soon as the data that is relevant or the custodians that are relevant are identified by interviews or by call correspondence from the regulator, you can collect that data, upload it, or we collect it directly. You can immediately start with your analysis, so you can immediately working on addressing your the gap in your information situation. You can very quickly identify what the problems are, why it happened, and what really happened. And you don't need to wait for third parties. You don't need to wait for forensic accountants or other people that have to do an investigation. But you can immediately start with that. Auto-redaction, anonymization, and pseudonymization helps you to protect data that comes from the European Union, which is also important if you are a U.S. company and you have European subsidiaries, or if you are a European company, you have to disclose to a U.S. regulator. What we see is that law firms in general are more competitive by using the same technology as many regulatory agencies. You have a lower risk for errors, and also important, you can keep your junior lawyers happy by sparing them boring and demotivating manual review and redaction work, which really nobody likes these days. Got a great quote here from one of our clients who said that although Xylem has some really complex technology, we take care of the whole process. We help them to support the lawyer, to think commercially, to provide comfort with the use of advanced technology. And I think this is very important. We are not just selling technology. We also understand that technology could be hard for a law firm to understand, and therefore we help law firms to defensively use this type of technology and understand what's going on. So you know, they can trust and do their work, and they can trust the technology, and they don't have to worry about any type of technical risks. So never bring a knife to a gunfight, because many of these regulatory agencies are using very advanced technology, and many of them are now doing inquiries for RFPs to buy even more advanced technology. We see these RFPs going by. If you are not at par, then after your seizure or dawn rate, you already are 3-0 behind, as I said. And then if you're not using the right technology, you may be even behind further or get further. Okay, now our technology is used for not only these regulatory requests, it's also used for litigation, dispute resolution, arbitration, and also for internal investigations. It's a similar use case, but we provide technology for our clients use our technology for exactly the same. All of these different use cases next to the one for answering regulatory requests. We wrote an ebook on this with all the tips explained and also the software explained with screenshots in more detail. So if you're interested and if you want to have a demo, let us know, and then we'll show you how we use this technology to accelerate through finding missions and help you to find the who, the when, the where, why, what, how much, by which means. And to make this answering of a regulatory request as efficient as possible. Okay, that's it from my side, Mary.
Oh, thanks, Jan. Well, I have a question. May, are you seeing the regulators being open to output from artificial intelligence or data mining techniques to narrow scope at all?
Not from personal experience, but if you look at how things evolved, new technologies came out and about all the time. I think it's about asking for permission, explaining what kind of tools you are going to employ, provide documentation, and seek approval, just like deduplication across custodians when that was an issue, and predictive coding protocol. I think the next thing would be to seek approval for an AI protocol to identify, just like Jan said, emotions, ideas, to help narrow or focus on the truly responsive documents. I think, again, it's going to be a natural development. And as long as the regulator understands what you're doing, and they'll definitely consider buying into it.
Yeah, we see the same. There's so much data, and you have to do it defensible and transparent. You have to explain them what technology you use and how you use it and how you validate the quality. But they're absolutely open for it.
See, we have a technical question, Jan. Does Zilab use graph databases and visualizations beyond email linking?
Okay, yeah, that's a very good question. What we actually do is that we can export our data to tools like Gephi, which is an open source tool, but also to Microsoft Business Intelligence, Power BI. And then there's a very rich library of data visualization in there. And that's what we typically use for community detection and other analysis that we make. I hope that answered the question. Otherwise, contact us and we'll give you a demo.
That's a good answer, yeah. That's a very good answer. Now, you were talking about having the review behind the firewall or in country. Are you seeing it? Are you seeing the multinationals in Europe or in the East? Are they more comfortable now with cloud technologies, or are you still seeing more like keeping it within the boundaries?
You're asking about me or May? Or
I was asking May. Yeah.
I thought that you were asking another question. Could you please repeat it?
Oh, I'm sorry. I was asking if you were seeing any, what your experience is with multinational firms in the cloud, in particular.
I have to say that it really depends. I have some multinationals who work with local clouds. I know some multinationals who architect their system to save data in the friendliest jurisdictions, data privacy-wise. And I have experience with multinationals refusing to use any cloud solutions when it came to their U.S. operations or in connection with discovery because of these data privacy issues and ownership issues. So I had clients that pushed back, but then I had clients that, when I came in to collect, used Office 365 and hosted in Singapore.
Yeah, no, we see the same. But we do see more acceptance with Azure, because Azure is guaranteed to run in a certain data center in a certain jurisdiction. And that's acceptable. Also, Azure is actually accepted by a number of the financial regulators here in Europe. So banks can store their email and other data in Azure and in 365. So it's absolutely changing. But it depends on the country.
Oh,
Certain
yeah.
countries, the cloud deployment in Europe is very high. Like in the Netherlands, it's very, very high. In other countries, it's a little bit lower. But the overall trend is that it's increasing.
Well, that Azure commitment on jurisdiction is relatively new, isn't it?
They've been doing that for a while, yeah. And now there's still some discussions that, Azure being owned by Microsoft, can you as authorities then claim data that's in Azure in Europe, and that's where the big fight is over in Luxembourg, where the last word hasn't been said about that. But the Azure, Microsoft is fighting very hard and refuses to give data to the US authorities, and they say they're not the owner of the data, but the client is the owner of the data. And but yeah, they have data centers in all the different jurisdictions in Europe, where AWS, Amazon doesn't have that, or Google. That's a huge benefit.
Interesting. So, May, do you have any final words of wisdom for our listeners?
Regulatory investigations could be daunting. It could come as a shock to the client, and I think that as practitioners, as attorneys, again, from my perspective, I feel that assisting clients with vendor retention, choosing the right vendor, communicating effectively with the regulator, and assembling a dedicated response team within the firm could make a huge difference at the end of the day. Better ability to control cost, and most important, at the end of the day, deliver a sound, foolproof, near perfect production as we're required to do.
Yeah. No, and if you want to see a demo
how
we do that at Xylab, then call us and we'll give you a demo.
Well, fantastic. Well, I want to thank May and Jan for a wonderful walk through the regulatory request response process. This is something that not all of us have the depth of experience that you two have, and we're very grateful for you coming to our community to share your knowledge. We'll be following up. There'll be an archive of this presentation that you'll be able to view, and we'll send you a link to that. And I think we have one last question. Let's see. Oh, no. We got a couple of compliments here, Jan and May. So thank you very much, and I thank all of you for your kind attention, and we'll see you at our next webinar.
Thank you.
Okay, thank you very much. Bye-bye.
Thank you.